My husband, God rest his soul, always said that the difference between an argument and a lawsuit is that one is about feelings and the other is about rules. I learned the truth of that when my own son, a man I taught to tie his shoes, used the rules of the probate court of Cook County to try and have me declared a senile old woman. He didn't come with shouting or threats. He came with paperwork. And in the modern world, paperwork is a far more effective weapon than a fist. It began on a Tuesday. Tuesdays were for baking. The house would smell of yeast and cinnamon, a fragrant anchor in the week. I was in the kitchen, flour dusting my apron like early snow, when the doorbell rang. Not the impatient buzz of a parcel delivery, but a single, formal chime. I opened the door to find a woman with a kind, professionally neutral face and a leather-bound clipboard. "Mrs. Eleanor Vance?" she asked, though it wasn't really a question. She knew who I was. "Yes? Can I help you?" "I'm Dr. Allison Ross, a court-appointed evaluator. I'm here for a routine assessment as part of the guardianship petition filed on your behalf." The words landed like physical blows. Guardianship. Petition. Court-appointed. The hallway, with its familiar Persian runner and the framed photos of my family, seemed to tilt. "I'm sorry," I said, my voice strangely calm. "A petition for what?" "For guardianship over your person, Mrs. Vance. Your son, Robert, is concerned about your welfare. He believes you may no longer have the capacity to make safe decisions for yourself." She offered a sympathetic smile that didn't reach her eyes. "May I come in?" I stepped back, my mind racing. Robert. My firstborn. The CEO. He had been distant lately, impatient with my sentimentality, about the house, about the way we'd always done things. He and Charlotte, his lawyer wife, had been making more comments. "This house is too big for you, Mother. You shouldn't be worrying about finances at your age." I'd thought it was concern. I was a fool. Dr. Ross sat primly on the edge of my chintz sofa. "Your son is very concerned. He says you've been forgetful. That you tried to donate a large sum to a television evangelist." I kept my voice steady, though my hands trembled in my lap. "I have never watched televangelism. My son, however, has a $2 million bridge loan against the Vance Holdings Trust coming due next month." "Is that in your report?" The evaluator's pen stopped its scratching. She looked up, her neutral mask slipping for a fraction of a second. "The trust? That's a separate matter. My evaluation pertains to your cognitive state." "Does it?" I asked softly. "Or does it pertain to my son's liquidity?" The interview continued, a humiliating litany of questions. "What year is it? Who is the president?" Count backward from 100 by sevens. I answered each one correctly, my pride curdling into a cold, hard knot of betrayal. This was Robert's opening move. Not a family discussion, but a legal ambush. He wasn't just stealing my home. He was using a durable power of attorney I'd granted him for medical emergencies to petition the court to strip me of my very autonomy. The first I knew of it was this woman, this stranger, sitting in my living room and questioning my sanity. By the end of the week, the cage had been built around me. Robert, acting under the color of the POA, had frozen my personal bank accounts. A woman named Brenda, a caregiver with the demeanor of a prison warden, was installed in the guest room to assist me. My movements were restricted. My mail was screened. I was a prisoner in a gilded cage, guarded by my own son's hired help. The helplessness was a physical weight. I would sit by the window in my late husband Arthur's study, watching the world go by without me. I saw my life, my identity as Eleanor Vance, matriarch, philanthropist, being systematically erased, replaced with the label Ward. Robert and Charlotte visited once, their faces masks of patronizing concern. "It's for your own good, Mother," Robert said, not meeting my eyes. "The financial decisions you were about to make, that donation, we couldn't stand by and watch you ruin yourself." "What donation?" I asked, my voice flat. Charlotte, ever the lawyer, stepped in. "The one to the Divine Light Ministry. We have the bank draft you initiated." Thankfully, Robert was able to stop it. It was a brilliant, malicious fiction. Create a paper trail of incompetence. Isolate the target. Seize control. They had learned too well from Arthur. But Arthur had used his shrewdness to build. They were using it to dismantle. I was drowning in their legal fiction. But they had made one mistake. They assumed the heart had no memory for detail. They forgot about Beatrice. Beatrice B. Croft had been Arthur's consigliere, a razor-sharp partner at the boutique firm that structured our entire estate, the trusts, the LLCs, the labyrinthine financial architecture that was Arthur's life's work. Bea was retired now, but she and Arthur had been like siblings, bound by a shared love of the law's elegant complexities. She had known Robert since he was in diapers. They monitored my phone, but they didn't know about the landline in the library. An old, brass-handled thing, its number unlisted, a relic Arthur had kept for emergencies. I waited until 3 a.m., when the house was silent except for Brenda's snores. I crept into the library, the cold floorboards against my bare feet, and dialed a number I hadn't called in years. The phone rang twice. Croft Residence. The voice was alert, despite the hour. Bea had always been a light sleeper. "Bea," I whispered, my voice cracking. "It's Eleanor Vance. Robert has filed for guardianship." There was a sharp intake of breath on the other end, then the sound of a keyboard clicking, rapid and precise. "Where? What county?" "Cook County, Illinois." Bea actually laughed. A dry, legal sound, devoid of humor. "He's an idiot. The Vance Holdings Trust has a forum selection clause. Delaware Chancery Court. He just filed in the wrong court." The typing continued. "This is going to be expensive." For him. A flicker of hope, the first I'd felt in days, ignited in my chest. "What does that mean, Bea?" "It means, my dear Eleanor, that your son has brought a knife to a gunfight and he doesn't even know what a gun looks like. The primary asset, the holding company, isn't in your name. It's in a revocable living trust. And that trust document is very clear. Any challenge to the grantor's competency must be adjudicated in Delaware. His entire petition here is jurisdictionally invalid for the trust assets. It's a procedural error of the highest order." She paused. "And the POA he used to freeze your accounts explicitly forbids using it to alter estate plans or petition for guardianship. He's already in breach of his fiduciary duty." The language was foreign, but the meaning was clear. Robert had tripped over his own haste. He had seen the prize but hadn't read the rules of the game. "What do we do?" I asked, feeling a new strength seeping into me through the phone line. Bea said, her voice crisp with purpose. "Go on the offensive. I'm reactivating my bar status. First, we file a motion in Delaware to have Robert removed as a trustee for breach of fiduciary duty. Simultaneously, we file a petition for a special administrator in the Cook County Probate Court. We argue that since Robert's actions are under direct challenge in the proper venue, an independent, neutral third party must be appointed to manage your personal affairs pending the outcome. That will freeze his control over you immediately. Then, we sue him personally for the legal fees he's forcing you to incur. We fight law with better law." And so, the battle was joined. Bea became my general. From my gilded prison, I provided her with every detail, every whispered conversation, every piece of the puzzle. Brenda, the caregiver, was merely an inconvenience. I played the part of the confused old woman, all the while gathering intelligence under her nose. BA's legal maneuvers were masterful. The petition for a special administrator was granted within days. A stern, gray-haired man named Mr. Sterling arrived at the house, presented his credentials to a flustered Brenda, and effectively sidelined Robert. My accounts were unfrozen. The cage door was swung open. Robert was incandescent with rage. The first hearing in Cook County was a disaster for him. The judge, after reviewing BA's motion regarding the Delaware clause, was clearly irritated at having his court's time wasted. Robert's local counsel floundered. The tide was turning. But Robert and Charlotte were cornered rats, and cornered rats fight dirty. A week after the disastrous hearing, a thick envelope arrived for me, hand-delivered by a courier. No return address. Inside was a sheaf of photocopied documents. A cover letter on Robert's personal stationery was succinct. "Mother, perhaps before you let that battle-axe B. Croft drag our family's name through the mud, you should consider the foundation upon which your fortune is built." Arthur's seminal patent for the Vance manufacturing process? It wasn't entirely his. The attached correspondence between Arthur and his former partner, David Rossi, suggests the core IP was misappropriated. While the statute of limitations has expired for a lawsuit, the scandal of this coming to light would be catastrophic. I'm sure the Rossi heirs would be fascinated. A scandal like this could trigger the clawback clause in the trust, inviting creditors to pick the estate clean for years. End this now. Sign the attached withdrawal of the Delaware petition, or I will release this to the press. Your son, Robert. My blood ran cold. I remembered David Rossi, a brilliant, hot-headed engineer who had worked with Arthur in the early, lean years. There had been a falling out, a bitter split. Arthur had always been tight-lipped about it, saying only that it was a painful but necessary business decision. Was this the truth? Was our entire life, our legacy, built on a theft? I scanned the documents. They were damning. Angry letters from Rossi accusing Arthur of stealing his ideas. Sketches that looked eerily similar to the final patent drawings. Robert had found a skeleton in the family closet, and he was prepared to rattle it until the whole house fell down. I called Bea, my voice shaking as I read her the letter. She said, nonplussed. The Rossi matter. I wondered if he'd dig that far. He's clever, I'll give him that. But he's not thorough. Bea, is it true? Did Arthur steal that patent? No, Eleanor, he did not, Bea said, her voice firm. What Robert has is the opening salvo in a negotiation, not the final settlement. David Rossi was a brilliant man, but unstable. He believed the idea was entirely his, but the patentable, commercial application was 100% Arthur's genius. Rossi threatened to sue. It was messy, but it was resolved. How? Arthur, being Arthur, didn't want a public fight. He paid Rossi a king's ransom, a confidential settlement of $750,000 in 1985, a fortune back then. In return, Rossi signed a settlement agreement and a general release, waiving all future claims. The matter was closed. Legally, conclusively closed. Robert found the angry letters, but he either didn't find the final agreement, or he's deliberately ignoring it to blackmail you. Relief washed over me, so potent it made me dizzy. So we have this agreement? I do. In my fireproof safe. Arthur gave me a copy for insurance. By threatening to expose a settled claim, Robert isn't just being a bully. He's further violating his fiduciary duty. He's acting in bad faith. This is our silver bullet. The final hearing in the Delaware Chancery Court was a study in legal theater. The courtroom was paneled in dark wood, the atmosphere hushed and solemn. Robert and Charlotte sat at the defendant's table, their confidence looking brittle. Bea and I sat opposite them. She was a vision of calm authority in a tailored suit. Robert's lawyer argued that his actions, while perhaps procedurally flawed, were motivated solely by concern for his mother's welfare. He painted me as a vulnerable old woman being manipulated by a ruthless lawyer. Then it was Bea's turn. She stood, a small, formidable figure. Your Honor, she began, her voice carrying effortlessly through the room. This case is not about competency. It is about credibility. And the credibility of the petitioner, Mr. Robert Vance, has been utterly destroyed by his own actions. She systematically dismantled his case. She entered into evidence the flawed POA, the jurisdictional error, the bad faith guardianship petition. Then she paused. But the most egregious act, Your Honor, demonstrates a level of malice that disqualifies Mr. Vance from any fiduciary role, now or forever. She held up a document. This is a letter Mr. Vance sent to his mother, my client, threatening to publicly expose a decades-old, fully settled business dispute in an attempt to blackmail her into dropping this action. Robert's lawyer shot to his feet. Objection. Relevance. It goes directly to the heart of good faith, Your Honor, Bea replied coolly. She approached the bench and handed the letter and another, older document to the judge. This second document is the settlement agreement and general release from 1985, which conclusively resolved the very matter Mr. Vance threatened to expose. He either knew of this agreement and suppressed it, or he was recklessly indifferent to the truth. In either case, his attempt to weaponize a false narrative against the very person he was duty-bound to protect constitutes a fraud on this court. The judge read the documents, his expression growing increasingly stern. He looked at Robert, who had gone pale. "Mr. Vance," the judge said, his voice low and dangerous. "Do you care to explain this?" Robert opened his mouth, but no sound came out. Charlotte gripped his arm, her knuckles white. The judge didn't need an explanation. The ruling was swift and brutal. Robert was permanently removed as trustee of all Vance family trusts. He was ordered to pay all my legal fees. Furthermore, he was held personally liable for financial penalties for his breach of fiduciary duty, a sum that would likely wipe out his personal assets. The gavel fell. It was over. In the echoing hallway outside the courtroom, Robert finally faced me. The arrogance was gone, replaced by a stunned devastation. "Mother, we were only trying to protect the family." I looked at my son, this stranger I had raised. There was no anger left in me, only a profound, weary sadness. "No, Robert," I said quietly. "You were only trying to protect yourself. You thought the law was a cage for me. You forgot that a cage, when you hold the key, can become a fortress." I turned and walked away, Bea at my side. We didn't look back. In the months that followed, with BA's counsel, I restructured the trusts. I inserted powerful no-contest clauses, ensuring that any future challenge would result in automatic disinheritance. I found a new, fierce joy in understanding the machinery of my own life. I was no longer just the heart of the family, I was now its steward, its chief legal officer. The house is quiet now. Robert and Charlotte are gone from my life. But the silence is no longer a prison, it is a peace I earned. Sometimes, in the deep quiet of the night, I sit in Arthur's study, and I can almost feel him there. I think he would be proud. Not of the victory, but of the lesson learned. The final lesson for my son was this: the most dangerous person in any courtroom is not the one with the most anger, but the one with the best lawyer and the cleanest hands. And I, Eleanor Vance, had both.